Victoria Aswenime. I'm a legal practitioner and the principal partner of Mavic Legal Advocates. We try as much as possible to roll out meaningful and useful content to our viewers on legal related matters. Please do well to like, to share, to comment, and even to recommend our content to others, because by so doing you may be helping someone out of that particular issue that they may be passing through. Thank you very much. So today we're going to be discussing tips on winning land matters, especially at the court of law. And I would start by saying land litigation is not an easy aspect of law, for both the litigants, that is the concerned parties, and also the litigating lawyer, because you must try as much as possible to prove your case beyond all doubt. And this will actually warrant you going extra miles to establish your claim to that particular portion of land that you are claiming, and you must rely on both your oral evidence at the court of law and also your documentary evidence that will back your oral evidence up. And I would say, amongst every other thing that you will do, there are some vital steps that you must take in establishing your claim so that the judge can smile at you, at the end of the case. And number one thing is to be able to identify your land, which means you must be able to identify with accuracy and precision your land. And when I say your land, quote me, I'm not saying the land you are litigating on, because at times you may have 5 acres of land and probably a part of the or a portion of the land is being encroached on. So you must be able to identify the expanse of land that is owned by you. That is our number one point. And our number 2 point is you must be able to identify the actual portion that is in dispute. Okay, now we are streamlining it down to the land you are laying claim to. Okay, and in identification we are talking about the physical identification and in documentation form. And in documentation form, we are saying you must be able to have a survey plan. You must be able to have your survey plan, and that is why I always advise clients at the point of purchase, try as much as possible to have your survey plan. It is not enough relying on receipt or any form of agreement, because even in that your agreement you can also incorporate that survey plan into it. Okay, so that you can have a document that will back your interest at the long run. Peradventure there is any litigation on the land, you can come out to say, okay, this was the particular portion I bought from so person, and this is the particular area that is we are litigating on, or that is being encroached on. So it is important to have a survey plan from onset. And coming to the dispute, the portion that you are laying claim to or that is in dispute, you must also have a dispute plan. As a claimant, immediately you realize that, okay, a portion of my land has been encroached on, the number one step you should take as a claimant is to have a dispute plan. And this is what you will use in backing up your claim at the court of law. Any papers that you are presenting before the court, you must be able to attach, you can attach probably the first survey plan that you have that is showing the land expanse of land that is owned by you, and also back it up with your dispute survey plan, which will reflect the portion of land that you are claiming in particular. And this dispute survey plan, it will help you because it is less stressful. In presenting your case at the court of law, it will show the exact location of your land and even the address of that particular land. It is so funny that at times the vendor may not even know the actual address of that land, but a surveyor, a registered surveyor, will know and will be able to state the address on the face of your survey plan and your dispute survey. Another thing you must present to the court in laying your facts are if there are any features on the land. Features like what? Features like, let's say, trees, let's say crops, and you must be specific. Okay, we have different kind of trees. Okay, you can streamline it by naming the name of that tree, by stating the name of that tree. It could be Iroko tree. Probably you have an Iroko trees on the land. You must be able to state, in fact, that okay, there are Iroko trees on the land. Crops, what kind of crops? Okay, is it maize? Is it fruit? Is it what kind of fruit do you have on the land? And features, like what again? Like rivers. Some have streams, passing through their land. Some footpaths, some rocks, some even shrine. Okay, you must be able to state in fact, in your court processes, features present on the land. And just like I rightly said, that if you are the claimant, you must have your dispute plan. Peradventure, you are the party on the other side, that is the defendant. Now you must also have your dispute plan, and we call it counter dispute plan in law. Okay, this will also state your own side of the story, and you will be able to back it up with your claim and with your facts before the court. And it does not really matter that you even have a judgment. You may have a judgment that has been gotten by some individuals in the past. Okay, you must also present a dispute survey plan. It is not wise enough to rely on the dispute survey plan of the other party, and that is why it is very important, because it's a personal suit. It is your claim. Okay, if you are laying a claim, it is your claim. Okay, it's not a joint claim with you and the other party. Probably, let's say, the claimant. It is not a joint claim with you as a claimant and the other party as the defendant. It's a personal claim, so you must pursue your interest, and in pursuing your interest, you must have your personal and respective documents to back up your facts at the court of law. So at this point, I would say, no matter how small the portion of the land you are claiming is, the procedures are the same. And that is why it is very important to go through the same processes. The procedures are the same, and you must be able to also trace the history of that land. Peradventure, you got the land through an individual, the private person. That individual must be able to state where he got the land from, and you must be able to reflect this in your agreement, okay, in that document that you both signed. And that peradventure, it's family land, you must be able to bring someone on board that can trace the history of that land. Okay, and that can be able to come to court to say you got the land from them. And lastly, I would advise that if you have any issue as to any aspect of your land, no matter how small the land, get a lawyer, because a lawyer will know what to do, and a lawyer will know the right document to get to support your claim at the court of law. So I hope this will be able to help you in your next claim. Thank you very much for watching. See you in our next video. Bye.